everyone, welcome back to our channel. Did you know that the system responsible for appointing judges in India is one of the most debated issues in the country's legal and political landscape? It's called the Collegium. And while it's meant to ensure judicial independence, it's also sparked a series of intense debates about transparency, accountability, and even fairness. This editorial is based on the Collegium and Changes, It May Still Be Early Days, published by The Hindu. The article brings into focus the complexities of India's collegium system, highlighting its efforts to ensure judicial independence while grappling with opacity, government delays, and the challenges of balancing autonomy with accountability. Now, what Indian collegium system actually is? Born from judicial interpretation, stands as the mechanism for appointing judges to the higher judiciary. While recent reforms like conducting interviews and limiting nepotism shows promise, this system continues to face challenges through the governmental delays and lack of formal binding rules. Though designed to ensure judicial independence, the opaque nature of its functioning and the government's ability to stall appointments have created a paradoxical situation where theoretical primacy meets practical constraints. This delicate balance between judicial autonomy and accountability remains a critical constitutional challenge even as the system attempts to evolve through incremental reforms. The collegium system actually refers to the mechanism for appointment and transfer of the judges in the Supreme Court and High Court of India. It's not explicitly mentioned in the Constitution but has evolved through various Supreme Court judgments. The Supreme Court Collegium consists of Chief Justice of India and four senior most Supreme Court judges, whereas High Court Collegium consists of Chief Justice of the High Court and its two senior most judges. Now let's talk about the constitutional provisions for judicial appointments. Article 124 states that Supreme Court judges are appointed by the President in consultation with the Chief Justice of India and other judges as necessary. And Article 217 states that High Court judges are appointed by the President in consultation with the Chief Justice of India, the Governor of the state, and the Chief Justice of the High Court. Now let's talk about the government's rule. The government can raise objections or seek clarifications. However, if the Collegium reiterates its recommendations, the government is bound to comply. Now comes the evolution of the Collegium system. The first judge's case, 1981. It held that consultation with the Chief Justice of India doesn't mean concurrence, gave primacy to the executive in judicial appointments. The second judge's case, 1993, states that overturned the first case judge's case, redefined consultation to mean concurrence, giving the Chief Justice of India a primary role. It introduced the concept of a collegium, requiring the Chief Justice of India to consult two senior most judges. The third judge's case, 1998, expanded the collegium to include the Chief Justice of India and four senior most judges, stated that dissent by even two collegium members can halt a recommendation. Now let's talk about the key benefits of the collegium system of India. The first one is judicial independence. The collegium system ensures judicial independence by keeping the process of judicial appointments free from the executive or legislative interference. This autonomy safeguards the judiciary's ability to act as a counter majoritarian institution, protecting constitutional values and fundamental rights. Moreover, government is litigant in majority of the cases, giving government a say in justice delivery might compromise the justice. Recent rulings such as the SC's verdict on the electoral bonds underscore the importance of a judiciary that is insulated from the political pressures. As per the fourth judge's case 2015, the collegium's primacy is integral to maintaining the judiciary's autonomy, a key feature of the constitution's basic structure. Now, the second key benefit is expertise driven selection. The collegium system ensures that judges, rather than politicians or bureaucrats, select appointees, promoting meritocracy and judicial competence. This peer driven selection process leverages the experience of senior judges to identify candidates with judicial acumen and integrity. For instance, the inclusion of specialists in the constitutional or commercial law strengthens the judiciary's ability to address complex legal challenges. Additionally, Supreme Court judgments on cryptocurrency regulation requires nuanced legal experience, highlighting the benefits of this system. Now comes the insulation from populism. The Collegium system acts as a bulwark against populism by ensuring judicial appointments are not swayed by transient public pressures. For instance, the Supreme Court's proactive stance on environmental protection and upholding demonstrates its impartiality. These cases reaffirm the judiciary's critical role in protecting constitutional democracy. And last comes the flexibility and responsiveness. The Collegium system, with its informal structure, allows flexibility to adapt to emerging judicial needs and challenges. Recent decisions to interview High Court candidates and avoid nepotism demonstrate a willingness to address criticism and enhance the process's credibility. This dynamic approach has resulted in the appointment of judges with significant trial court experience addressing long standing gaps in judicial diversity. This adaptability ensures that the judiciary evolves to meet societal expectations. Now, talking about the key issues related to the collegium system. The first one is lack of transparency. The collegium system is criticized for its opaque functioning, with decisions on judicial appointments often shrouded in secrecy and lacking accountability. The absence of publicly accessible criteria for selection undermines public confidence and raises questions in favoritism. For example, the controversial transfer of Justice Sanjay Kumar Mishra raised concerns about the rationale behind such decisions. Globally, India's ranks 79th of the Rule of Law Index 2023, reflecting its relative independence. Despite efforts like publishing resolutions online, inconsistency in disclosure still persists. The next key issue is nepotism and favoritism. Critics argue that the collegium system perpetuates nepotism, with many judges being related to existing or former judges, leading to a judiciary that appears elitist and non representative. Recent moves to exclude candidates with judicial kinship have been welcomed but remain inconsistently applied. A 2015 report stated that around 50% of the judges of High Court and 33% of judges of the Supreme Court were family members of those in higher echelons of judiciary, creating barriers for first generation lawyers. The next key issue is executive delays in appointments. Despite the collegium's primacy, the executive often delays approving its recommendations, stalling the process and creating judicial vacancies. While over 60 lakh cases remain pending at High Court across the country, 30% of the seats still remain vacant due to prolonged government inaction. For example, a 6-month delay by the government in approving the Collegium's recommendation for Justice Bidyut Ranjan Sarangi as Chief Justice of Jharkhand resulted in the judge receiving a tenure of only 15 days. Next key issue is lack of diversity. Despite recent improvements, the Collegium system have still been very slow to address issues of representation for women, marginalized communities, and regional identities. As of January 2024, only 13.4% of judges in the High Court and 9.3% of judges in the Supreme Court are women. Similarly, less than 25% of High Court's judges belong to SC, ST, OBCs, and minorities. The last key issue is judicial backlog and inefficiency. The lack of timely and consistent appointment process exacerbates the pendency of the cases, undermining public trust in the judiciary. A backlog of around 80,000 cases at India's Supreme Court is impeding access to justice. Judicial inefficiency costs India 1.5% of GDP annually, delaying crucial economic and social reforms. While the Collegium seeks merit based appointments, the inefficiencies in the operation counteracts its intended goals. Now, let's discuss what, according to me, are the measures that can be adopted to reform judicial appointments. Codification of collegium procedures. Codifying the collegium functioning into a formal institutional framework is essential to bring transparency, consistency, and accountability. Justice J.S. Kehar proposed that an advisory committee of eminent persons, including experienced lawyers, jurists, and retired judges, be consulted during the judicial appointment process. Next is reforming appointments of judges. The appointment system of judges need to be more transparent and accountable under the Right to Information Act, allowing citizens to access information on the selection process. The next one is enforceable time limits for appointments. Introducing strict enforceable timelines for the executive to process Collegium recommendations would address the chronic delays in the judicial appointments. Finally, to conclude, the Collegium system has played a crucial role in safeguarding judicial independence. However, its lack of transparency, executive delays, and limited diversity continue to present significant challenges. Reforms like codifying procedures, introducing enforceable timelines, and enhancing diversity would address these issues. A balance between judicial autonomy and accountability remains essential for the system's evolution. Ultimately, a more transparent, efficient, and inclusive approach can strengthen the judiciary and restore public's trust. That's all for today, guys. If you found this discussion thought provoking, make sure to give this video a thumbs up and share it with others who might be interested in this topic. I'd like to hear your views on the Collegium system. Do you think reforms are needed or it's working as intended? Drop your thoughts in the comments below. And if you haven't already, don't forget to subscribe for more in depth analysis of important legal and political issues. Thank you for tuning in, and I will catch you up in the next one.